Hi everyone and welcome to another Paddocks Club video tutorial. Recently one of the Paddocks Club's members asked a question on the body corporate making customized management rules. Specifically, it was asked whether the body corporate could amend their management rules in such a way that they would be in contravention or in conflict with the prescribed management rules. In order to answer this question, we need to look at some of the provisions contained in the Sectional Title Schemes Management Act and the regulations made thereunder. In terms of Section 10(1) of the Sectional Title Schemes Management Act, no provision in either the management or the conduct rules can conflict with any provision in the Act. The Act therefore establishes a hierarchy in which its provisions are predominant and they prevail over any conflicting provision in either the management or the conduct rules. Section 10(2)(b) of the Act states that no provision in the conduct rules can validly conflict with any provision in the prescribed management rules. Therefore, the management rules are subject to the Act, and the conduct rules are subject to both the provisions of the Act and the prescribed management rules. The body corporate can make management rules by unanimous resolution in conflict with the prescribed management rules, but it's important to remember that Section 10(3) of the Act requires that the rules be reasonable and apply equally to all owners of units. Any provision that is unreasonable will not constitute a valid rule. It's important to note that the requirement that the rule be reasonable should be based on the particular circumstances of the scheme and the members of the body corporate. There needs to be a rational basis for the interpretation, and the decision should be founded on what is appropriate and fair in the circumstances. This argument is strengthened by the fact that in terms of Section 10(5)(b) of the Act, the Chief Ombud must not approve any rule for filing unless he or she is satisfied that it is reasonable and appropriate to the scheme. An owner who feels that a rule is unreasonable can make an application in terms of Section 38 to the Community Schemes Ombud Service for an order declaring that a scheme governance provision having regard to the interests of all the owners and the occupiers in the scheme is unreasonable and requiring the association to approve and record a new scheme governance provision. They can remove the provision if appropriate, restore an earlier provision, amend the provision, or substitute a new provision. It's important to remember that the position is different for the developer. The developer is restricted in what management rules he can adopt. Regulation 6(3), made under the Sectional Title Schemes Management Act, states that a developer may substitute, amend, or withdraw management rules number 5(2), 5(3), 7, 8(1), and 8(2), and 12, and may add management rules that are not inconsistent with any other prescribed management rule when submitting an application for the opening of a sectional title register. Furthermore, the developer can only substitute any of the prescribed management rules in very limited circumstances. In terms of Regulation 6(4), the prescribed rules will not apply to a scheme if the schedule referred to in Section 11(3)(b) of the Sectional Titles Act contains a condition restricting transfer of the unit without the consent of an association whose constitution stipulates that all members of the body corporate of the development scheme of which the unit forms part must also be members of that association. And secondly, the functions and powers of the body corporate must be assigned to that association. I hope you've enjoyed this video tutorial and that you will find the information helpful. If you have any questions in this regard, please contact me at consulting@paddocks.co.za. Thanks for watching and goodbye.